right, terrific. My name is Will Trackman. I'm the General Counsel of Mountain States Legal Foundation, and we are excited for our monthly webinar called So a Neighbor Asked. And this month's session is So a Neighbor Asked, What's the Deal with Natural Resources Management? We kept it very broad so that we can have a nice, robust conversation with our panelists. And we are honored to have an August group here with us today. I'm going to do a couple of introductions of the folks that we have here for our discussion, and then we will open it up to the panelists. And then at the end, we'll have a Q&A period. So do think of those questions and feel free to submit your Q&A at any time during the period of the webinar. And we'll leave at least a few minutes at the end for Q&A. And also, I brought my glasses this month so I can read the Q&A, which is even more helpful. So with that, let me introduce first the panelists to my right, Ivan London, who is the chair of our Natural Resources Practice Group. Ivan's been with us for over a year now and litigates cases in natural resources management, in energy, and across the spectrum of natural resources and property rights. We're pleased to have him here as our in-house expert on natural resources issues. On the screen, we have two folks. We have Laura Chartrand, who's special counsel at the Buckhalter firm and the former regional solicitor in Region 8, which is Denver. She's got quite a bit of expertise on natural resources issues. We're excited to have her join us. And then we have Norm Semenko, is the managing shareholder at Parsons Bailey in Latimer, up in Idaho. Norm is also the vice chair of our Litigation Advisory Council and someone whose expertise runs the gamut of natural resources issues, in particular water. He's the chair of the firm's water group. And he is co-counsel with Mountain States Legal Foundation in a number of cases, including the Idaho Stockwater case, which just got a ruling yesterday, which I am excited to hear more about from Ivan and Norm. So with that, let's get started. Norm, I'm going to start with you. Tell us what you're working on and feel free to add some color to what I just said about the Idaho Stockwater decision yesterday.
Yeah, I'm going to leave the details to Ivan to take a first stab at. But first of all, appreciate the opportunity to chat with everyone about what's going on in the natural resource world. The case that Ivan and I are involved in southern Idaho, a Clean Water Act enforcement case. The Ace Black Ranches case is a fascinating case. It's a case where the United States was set its targets on our client even before the Sackett decision, and our review of that was that once the Sackett decision came out, once it was clear that there had to be a continuous surface water connection between the wetland and the actual river, the Bruno River in this case, such that the wetland and the river were indistinguishable, that the United States might back down a little bit. But rather than doing that, they doubled down. They doubled the size of the wetlands that they say are connected to the river. And Ivan put together a very straightforward argument for the court to look at, Judge Nye, the U.S. District Court judge in Idaho, with regard to whether this should be dismissed, the action on the wetlands. There are some other issues involved, but jurisdictionally, they didn't even allege what's required under Sackett to go forward with the case. And their response was basically, we don't have to, we've done enough. The judge can figure out where we're going. So we're waiting for that ruling, and that will obviously affect where the case goes, whether they have to, whether the case, that portion of the case is gone, or whether they get a chance to amend their pleadings, which is where they kind of toward the end of the briefing and in some supplemental authority citing seem to be concluding that they would where they would need to go. That will be fascinating itself because they've been out on the site for days on end with experts. Rule 11 starts kicking in a little bit. What can you really reasonably allege in terms of facts here? You've been out on the ground. So that's been occupying a lot of our time, a lot of our thought process, and we're very excited to see where this can go. We really would like to see the government get off of the ranchers' backs, the Ace Black Ranches folks. They have 100 and almost 40-year-old irrigation operation in southern Idaho, and they're just making a living. And they're close to the river. Someone complained, and here's the government.
Let's take a step back, since our audience is not just lawyers but also laymen, and talk about what the Sackett decision was, and then you flagged Rule 11 there. It's certainly something that that some folks might not know what it is, and then how the Sackett decision and the issues at play affect our clients here.
Sure. So just real quickly on the Rule 11 thing, it's just a basic rule of professional conduct for all of us lawyers that before we sign anything, before we file a complaint, before we take up the court's time by commencing an action, we have done the review. We're comfortable that the arguments are grounded in the facts and the law. We got a reasonable basis in fact and law. So what I'm insinuating here, not so subtly, is that the facts really on the ground don't justify a conclusion that these wetlands and the river are connected in a way that satisfies the Sackett decision. So what is Sackett? Sackett is a case out of North Idaho. Pacific Legal Foundation, our good friends over there in the Liberty Movement, brought this case on behalf of the Sacketts. It is an over decade old saga where they've been to the Supreme Court, U.S. Supreme Court twice. But the substantive issue is whether wetlands alleged wetlands near Priest Lake in North Idaho were waters of the United States. Are they so connected and so intertwined with the lake that they are themselves waters of the United States? The Ninth Circuit glommed onto the singular decision opinion by Judge Kennedy in the Rapanos case back in 2006. This was a decision where the court decided there wasn't jurisdiction over certain wetlands, and Justice Scalia penned the plurality decision saying, for something, a wetland to be a waters of the United States, it needs to be, connected. There needs to be a permanent surface water connection. You need to be able to not tell them apart. That was only 4 votes. So to get to the result of overturning what the government had done, Kennedy did concur, but his standalone opinion said, I think the test is a little different. I think it's just whether the wetland has a physical, biological, chemical connection with the river, a significant nexus, the significant nexus test. So over the next 10, 15 years, the circuit courts, the district courts struggled with which test to adopt. Coming back to the Sackett case, the Ninth Circuit had adopted the more liberal, the more permissive in terms of regulatory authority for the United States, significant nexus test. So the question that was before the Supreme Court on cert was, did the Ninth Circuit get the test right?
Yep.
When the U.S. Supreme Court granted cert, it was obvious they were going to reverse, and they ended up adopting the Scalia test of a permanent surface connection.
Makes sense. Well, let me turn it over to Laura. Can you tell us, Laura, what you're working on these days in the natural resources management area, and then what sorts of broad issues you think are trending or that may become trending in your world in the future?
That's a big question, but I wondered if I could add something
Yes, please.
to the discussion on Sackett.
Yeah.
And, Sackett really, the court, I think, was persuaded. What could a layperson see? Like, was it apparent to a layperson that this was connected to waters of the United States? And on constitutional reasons, the court adopted the more conservative view, test as to whether there is a connection or not. But now we see a trend of some states wanting to fill the gap that's created. And so they are, in Colorado, where I practice, is the first state to pass a comprehensive bill that then will prop up a state program for dredge and fill. And it will be interesting to see if there will be constitutional challenges that can a state build a program predicated on something that the Supreme Court has deemed unconstitutional. And it'll be interesting to see if there's a case that emerges from that. So I think that could be one to watch from a state perspective. And it's also challenging for folks who operate in more than one state. And we do see farming operations, ranching operations. It's not uncommon. I have a client who he has land in Utah, Colorado, and Wyoming. And so now he's got to navigate different systems as he's thinking about how does he operate his ranch, how does it impact wetlands, and it becomes a greater burden for him in that instance. So a lot of my work is in water litigation, water rights litigation. I also do a fair amount of transactional work in the water arena, supporting entities who supply water to support oil and gas operations, both in Colorado, and I've been doing some work in other states, including North Dakota, which is a lot more straightforward in order to support oil and gas operations there. And then I have a new part of my practice, which is before the Colorado and California Public Utilities Commission, where I represent different entities. My focus in California is representing industrial entities who are trying to keep the rates down. And California, in essence, is the canary in a coal mine in that it has very aggressive renewable energy goals. And we're seeing this play out and what that does to rates. In particular, in Colorado, who oftentimes will model some of their priorities after California. I had the honor really to represent Moffat County and the city of Craig, Colorado, which is home to an electric co-op coal-fired plant, different units of a coal-fired plant that are being shuttered because of the shift from fossil fuels to renewables. And that will mean that 45% of the property tax revenue for that county and that city disappears. So support for their schools, their hospitals, their infrastructure will essentially disappear. And you know, whose responsibility it is to kind of set that county up and the city up for their next evolution after that plant closes. And in this case, we were very fortunate that the electric co-op was very open, and we negotiated a settlement agreement where they're providing a package, a resource package, an economic development fund, in addition to water rights, so that they can develop different industries, you know, valued at $73 million. But that is on the back of the co-ops, right? They're supporting that transition. And while the state has some grant money and loan money, it pales in comparison as to what's necessary in order to keep the vitality of that community and how they reimagine what comes for them next. So they're desperately fighting for new industry to keep their residents who make a choice, right? They make a choice that they want to live in a rural community. They're raising their families here. They're working hard to support their quality of life. And that can't be replaced by working at McDonald's. These are high-paying jobs. And so this then gives some resources to that particular county and city to hopefully attract new industry. And there's a workforce waiting for them. And so that's probably something that I'm most excited and proud about right now.
Amazing. Yeah, I've seen your posts about that. Terrific work. And I imagine it must be nice to have some of that behind you and tremendous pride in that.
Yeah.
I want to go back to the one thing you said, which is that California is the canary in the coal mine. You know, the canary in the coal mine either lives or dies, depending on how dangerous the coal mine is. That seems like pretty high stakes to be the canary in the coal mine. You know, I might use a different analogy to how much can you strangle the golden goose before it dies? How worried should we be? Yeah, how worried should we be about, you know, that model where California is the canary in the coal mine?
I think that the worry is, where's the tipping point financially? How much can our economies bear, and who's asked to bear these policy positions? And so, you know, I think folks who are interested in justice, social justice, should be concerned, because it is the low income folks who really struggle to pay their electric bill as it is. And this is just magnified for states like California, who have to shore up a lot of infrastructure as they disconnect from more traditional fuel sources. And then it also impacts industry, employers who have to take a look at, can I operate more cheaply in other states? And I don't know that we've seen, I don't think we've seen the full impact of those policy decisions yet. And so there's more to learn from the goose or the canary in the next
Some kind of
few
bird.
years.
Yeah.
Yeah, some kind of bird.
If I could.
Please.
Yeah. So
yeah.
I mean, it's on that point. We are involved right now in a case that's pending for review at the Supreme Court, where parties have asked the Supreme Court to review this question of what is California's role in setting federal policy, right? As a state, how do you state or set federal policy? This in particular involves California's tail emissions requirements for automobiles and the not implicit, explicit requirement that there be no more fossil fuel powered vehicles here in the next 20 years or so, actually more like 10 years. And so that's a case that's gone in front of, the technical details under the Clean Air Act can be a little wonky, if I'm being honest, right? But the issue is in front of the Supreme Court right now, and we're involved. We represent several, a couple of different trade groups represent many different royalty owners, oil and gas royalty owners, to explain to the court why you should give really close look at this consideration of how do we let one state set a federal policy that will impact people throughout the country who might not be in the direct line of fire, so to speak, but will be devastated by these actions. And so that's the EV mandate case that's at the Supreme Court right now. There are several states that involves Ohio v. EPA, in case you guys want to look it up.
Yeah, and it's important work, right? It's absolutely critical work because California is dictating what types of vehicles are going to be accessible to the entire country, right? Because of that. And it impacts manufacturers who aren't necessarily located in California. And it does have nationwide impacts.
Sure.
And it's to California's benefit as a state, to their economy and to their policy positions if other states are forced along, because then there's no competition. Industry's not looking to leave California because all of the states have to be in the same framework. I also think that we do, whether you want to talk about wildfires or not, we do have to. I'm just a person who supports an all of the above scenario. And I don't like to pick losers. I think our energy solutions are founded in a diversity of portfolios. So I just want to be clear, I'm not suggesting that we just decouple entirely from renewables. That will happen, just like coal. Coal has eventually it's no longer as prominent as it used to be. And we can help shore up those people who are impacted by that, like we did with Moffat County and the city of Craig. But we also have to be a little bit more realistic about our trajectory and can we really decouple from fossil fuels? And what does it mean? What does that look like if we do that?
And Laura, also, who decides, right?
Yes.
Question.
Yeah, absolutely.
That's really the gist, the thrust of the case that's now the Supreme Court asking the court to at least review the case and give us an answer of who decides. And there again, like I said, we represent not, for example, the automobile manufacturers or even the refiners. It's, for the oil and gas royalty owners, and that's property. It's a property right that's being written out of existence by one state and applied nationally. So we hope the court will take review. If I could abstract for 1 minute, actually.
Well, the next question was for you.
Okay,
so
good. Let me get started first. Let me get a wind up for you.
What are you working on?
Well, the second, I'm sure we'll talk about Loper, Bright, and Chevron deference too. So one point that came up during the SACIT discussion and the Water United States discussion, right? These important opinions come out and decisions come out from the U.S. Supreme Court, and the question you get 1 hour later before you've read 500 pages is, what does this mean? And a lot of the cases we deal with, and some of the ones we're talking about, including Norm's discussion of our Ace Black Ranches cases. We get to go fight about what it means, right? Surely the Sackett case, for example, came out a year ago, but it has to mean something. And at this point in our Ace Black Ranches case, that's exactly what the briefing is about. To kind of reiterate what maybe some of the facts that Norm said, the U.S. government went out for days at a time, twice. There were armed marshals involved. Maybe to avoid that fact, but and then they found, rather than negotiating what might or might not have happened, what could be done to fix the situation if they thought something needed to be fixed out at this large ranch, they just filed a lawsuit and wield that as a hammer, right? We have all the authority, we have all the power, we're going to bring you to court. What we've done is asked the court to dismiss the allegations about the wetlands because the allegations themselves, we're not even getting to proving anything yet. They don't appreciate, they basically ignore the Sackett opinion. They pay lip service to it without actually explaining what anyone did wrong. And we feel like, again, what does Sackett mean? It has to mean something. And the government has to at least even allege and allege the facts. You guys were out there. Was the ground wet? Right? Did you take pictures? What'd you see? They don't bother doing any of that because it's inconvenient for them. They'd rather, state a legal conclusion. Oh, it was within our jurisdiction, and have the judge kind of, go back and, backfill, pun intended, the facts needed to get there. And that's not what our system requires. And it lets the agencies, again, wield litigation as a hammer, a real heavy hammer, when they don't feel like they're constrained by actually having to prove their cases and explain what their cases are. So we're going to get, I'm sure, with the local right also and all that stuff. So these cases, the important Supreme Court decisions take some years to figure out what does it mean. It doesn't have to mean something. And that's what we're engaged in.
Yeah. Do you want to talk about Idaho stock water or?
Well, I'd be happy to. Yeah, it's a little bit of a. A reporter this morning from Boston who did not maybe appreciate that water in the West is different from water in the East. And luckily, our federal Congress, our United States Congress, has realized that and required that when the U.S. federal government's dealing with water rights out in the West, it has to be on a level playing field as everybody else. Right? They don't get some priority. They don't get some supremacy. They don't get to hoard water and then use that hoarding to strong arm landowners. There are rules in place out West, and the U.S. government, the federal government, has to follow them too. Now, I know stock water has a long history, but short version is U.S. did not think that the laws governing the use of stock water in Idaho, whether common law or statutory law, really applied to the U.S. There were some statutes that the Idaho government and legislature enacted that targeted the U.S. And others that really just put up a procedure to make sure that everyone's on a level playing field. And so the U.S. sued to get rid of all those statutes that require.
They sued as a plaintiff.
They sued as a plaintiff. The U.S. sued the state of Idaho. We intervened on behalf of several ranchers who use stock water in the West. And Idaho law is clear. The way that you get a water right to stock water is to use it. The federal government was not using the water. The ranchers were. This case is not specifically about any particular water right. It's about whether there could be a process to figure out who has the water right. The U.S. didn't like that because the U.S. could, but doesn't own livestock. It doesn't water the livestock in their stock water ponds.
Maybe it did at some point own livestock, but given government management.
Very little. But there's been Idaho law for a century plus now that you have to actually water your livestock under these old decisions of who has the water right. And so last night we did get a ruling on that. I argued it with Norm. We were there in January. And we got a ruling from the district court up there in Idaho that, Congress's McCarran Amendment, which is the law, federal law that says that federal agencies have to comply with state water law policies and limitations and requirements. It means what it says. So if Idaho sets up a procedure to decide whether anyone still owns their stock water right, whether it should be kind of put back into the general system for obtaining that right, the U.S. has to play ball, right? They're on the same level playing field as everybody else. So we consider that a big win.
And what's shocking here is that's been well decided. That's been well decided. And if organizations like you don't exist so that people can engage, where they shouldn't have to engage, right?
Mhm.
That's the disappointment. And it goes back to your, other question. Sackett should mean something.
That's right.
These decisions should mean something. And I just know when I worked for the Department of Interior, that it meant something to me, like what the law was.
Mhm.
And you kind of have to ask the question, not only about a specific agency, but if they're an agency in which the Department of Justice is in charge of litigating, why is the Department of Justice taking a look at something like the McCarran line of law and saying that doesn't apply here? It's just, it seems
Yeah.
very egregious to me.
Yeah. My personal take on that is that there were a couple of the Idaho statutes involved that did target the U.S. government, and they use that as a hook, try to upset the entire system, right? And the judge, I think, very adroitly was able to separate one from the other and leave this important system in place that benefits. It benefits the ranchers in the sense that they're on the same playing field, right? And a lot of the work we do, you can go back to Chevron deference again, right? And we'll go back to it or get to it, is that we try to make sure it's a level playing field, right? That it's fair. And so I think in that, my first read of the ruling from last night is that's what we're
Yeah. Norm, I want to throw it back to you. Serve on our litigation advisory council. Obviously, MSLF is a liberty-oriented law firm. Do you see in your work or in the trends in the resource management area opportunities for deregulation or increasing the amount of autonomy that people have over their property or their natural resources? Give us some hope for optimism in terms of what you're seeing on the ground.
Yeah, I think with this, it's a great question. With this administration, it's exceedingly difficult to foresee that. We'll see if there's a change come the November election. However, between the major questions doctrine and overturning Chevron, there is a tremendous amount of hope that some of these regulations that stifle private enterprise, that stifle American ingenuity, are going to be shunted to the side. I mean, when you've got questionable statutory authority and very questionable, which brings in the issue of the major questions doctrine. So the major questions doctrine, now the West Virginia case, U.S. Supreme Court case, is if Congress didn't speak to it, and it's such a major issue, Congress didn't say, hey, agency, we want you to regulate in this area, greenhouse gas emissions, whatever it is, go make regulations about this. If Congress didn't speak to it, EPA can't just start making stuff up. So between that and then the issue on Chevron is, hey, we're gonna historically defer to an agency's reasonable interpretation of what a statute means. So Congress did speak in this area, and now it's up to the agency to come up with regulations. The court said, no, we're not going to do that anymore. The judges, the courts decide what the law means. So agency, you better be coming up with the best interpretation of the statute, because that's what we're going to be looking for as judges. There are any number of regulations that stifle growth in industry out there that are not the best interpretation. So we're seeing a huge influx of lawsuits now, emergency petitions. We can go into details, but it does give me cause for hope. Even while this administration's in place, that some of that can be rolled back.
Yeah,
I'd say, Norm, I think you'd nod your head to this. The flip side is that we've also seen some federal actors double down, right? You mentioned the ABR case, and that's exactly what we saw there. Our question is, doesn't Sackett mean something? And rather than kind of agreeing with us on what is straightforward, what we've seen is maybe, it's ignoring or overtly rejecting Supreme Court decision. The DOJ or their clients, the agencies involved, have decided, no, we're going to actually go harder. We're going to pay lip service to it and do what we want to do anyway. Maybe even raise the stakes for you so you don't want to fight us anymore. I
agree 100%. I agree. Yeah.
It's in the balance. Let's call it that, right? And that's like I
agree,
said, that's
100%.
The point is, these cases have to mean something. Yeah.
Yeah, and I
agree
think
100%.
that's
sorry.
we
Or-
always say this, we talk about this, is that elections matter, and who's who's ultimately making these decisions to proceed in litigation. And for most of these agencies, you need the Department of Justice to sign off on litigation. You don't get to just litigate without the blessing of DOJ.
Norm, my favorite example of the major questions doctrine is Justice Barrett's example of the parents who give the babysitter a credit card and say, make sure the kids have fun. And then they come home and the babysitter's taking the kids to Disneyland. And so, well, you said that they should have fun. That there's that's inconsistent with the clear intention of the credit card giving, and you need a clear statement from the parents that that's what you want before you can abscond with the children.
Yeah.
Well, Laura, I'll toss the same question to you in terms of optimism and deregulatory opportunities. I'll start by saying we're a nonprofit. We don't endorse candidates or have an official position in the election. But what's on the horizon in terms of liberty-oriented trends that may increase our property rights, our natural resources autonomy?
Well, I have a client that comes to mind that I'm representing, and he's an owner of a glass company. And he actually services military housing units where he does their glass repair on DoD property. And if it's a DoD property, there's no recording of title that my client can look to see how old the housing is. And so he's at the beginning part of an enforcement action against EPA because they're alleging he didn't follow the Toxic Substance Control Act, specifically the Lead Paint Act, and that he didn't take certain steps. And I think the glimmer of hope that I have here for some poor businessman, I'm not gonna say he's a poor businessman. He employs 85 people in a major community on the Front Range of Colorado. He pays his taxes. He's a good man. He's been married to his high school sweetheart from 5th grade. They've been together raising a family. And this is really important to him. And he's now at risk of daily fines from the EPA. The good news here is I think they're kind of stopped in their tracks as a result of the Supreme Court decisions and how we pushed back on EPA. So the unfortunate part is that he's kind of in this purgatory in which he's not getting a conclusive, we're closing out this investigation, so he doesn't have the stress of wondering when the EPA is coming knocking. But I do think we may see agencies kind of slow down, perhaps on some of their enforcement actions, because they have to take a look at what the law says, because the stakes are just too high. And that's why I think maybe in the terms of whether there's civil penalties, that they'll be a little bit more cautious. But generally, I'm not necessarily an optimistic person when it comes to
how full is this water glass?
When it comes to, I think the federal government is clunky and cumbersome, and there's not a lot of consistency. Sometimes it's the field person who's driving litigation decisions or enforcement decisions, and there can be a disconnect with who's watching that. And so I just think that it's just really important that if folks think this doesn't make sense, that you talk to other people so that you can get help when things don't make sense. Because if they don't make sense to you, there's probably a good legal theory to support and advocate on your behalf.
Yeah, it's actually, we're happy to have you in the private sector, but we miss you as regional solicitor for Interior because you were one of the good ones in the bureaucracy.
Well, and one thing that I wanted to talk about, just to make sure folks understand what's going on with BLM specifically, and I think that impacts a lot of different folks who may be oil and gas royalty owners, ranchers, farmers who have grazing rights, other interests, or even just people who use the public lands for recreation or hunting and fishing. In June this year, the Biden and Harris administration successfully began their public land rule. Some folks are calling it the Conservation and Landscape Health Rule. And what it does is it, for the first time, prioritizes conservation. And the problem under the law, from my perspective, is that BLM has a multiple use mandate under a different law that we refer to as FLPMA, which is the Federal Land Policy and Management Act, which it enumerates the different uses for BLM land. It does not include conservation. It includes energy, mining, recreation, other uses, but conservation is not one of those uses. So here's a situation where we have policymakers essentially creating law, in my opinion. And the good news is there's at least 2 current lawsuits challenging the state of Utah and Wyoming have filed in Utah District Court. And then there's a coalition of 12 different entities who have sued in Wyoming District Court. They represent anything from grazing and farming, ranchers, to oil and gas, to electric co-ops who are challenging the rule. So I'm hoping that we get another look at this. There's a provision here that would allow BLM to withdraw land from public use under the premise of it's called a restoration and mitigation lease, where I think the fear may be that environmental groups will tie up large swaths of public land under this type of lease. It potentially could be used also to help support development, depending on who's making decisions around who gets those leases and for what purpose, because it could help someone offset under a compensatory mitigation process. So it might not all be bad, except for when it comes out of restoration, BLM has indicated that it will only allow what they call casual uses, which is recreation, hunting and fishing. So it's a way to withdraw land from the full multiple use charge responsibility that BLM has. So I think it's something we need to monitor and watch and be concerned about.
Yeah. Just a reminder that we do have a Q&A box. If you have a question, to go ahead and drop it there. We'll have a few minutes to do Q&A. Ivan, why don't I turn it over to you? I want you to comment on everything that Laura and Norm have said, but then also in terms of energy, I feel like Americans are using more energy than ever. I'm certainly, charging my iPhone more times than ever every day, and yet there are threats to our energy supply and our energy usage. So if you don't mind commenting on both, anything that you want to comment about Norm and Laura's comments, and then also that need for energy that you're seeing right now.
So we're going an extra hour, right?
Ha 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 ha.
My only quibble with what Laura said is actually it's not the first time that the Department of Interior has tried to do this with the conservation lease. Oh, in the 1990s, they tried to do this through the Taylor Grazing Act and basically write grazing out of the law by creating grazing leases that forbade grazing. And that was rejected by the 10th Circuit Court of Appeals here, based in Denver. So this is not the first time, but they found a different lever. We have been very active on this front, both commenting on the proposed rule, getting involved maybe afterward, and then seeing this across. There are many levers the federal government has to pull to try to kind of push what I've repeatedly called in briefing and otherwise an anti-use position. right? I mean, sometimes we're against other groups that people call them environmentalists. I call them anti-dash, whatever we're trying to do here. And so the anti-use groups, and the idea is, yeah, to tie up lands. And there are many levers, and not just the conservation leasing which applies to federal lands. There are certainly at least questions that we've looked at closely regarding tying up lands through conservation easements the federal government pays money for. And, there are legitimate ways to do that. And the last person to tell someone what to do with their land. But there are also maybe, chances to see whether there have been some shenanigans. We have been involved certainly in the Antiquities Act, using monument designations to write uses of federal lands out of the law. And those are ongoing, and they have been for decades, frankly. And we're trying to get the right one in front of the Supreme Court. There are, going to the managerial level, resource management plans. We just got a publication about final rule in Southwest Wyoming that we commented on with 32 legislators of Wyoming. About the agency, again, whether it's major questions or outside or mission creep or whatever it is, right? Going beyond what the law allows, and also, where the law stops allowing things, it also limits things. Going beyond what the law allows and limits to create their own policies and their own rules, absent from any congressional authorization. That impacts oil and gas for sure, grazing for sure, mining for sure, but also active forest management, meaningful forest management, something we've dealt with a lot recently, especially. Even recreation, right? And to put a little color on what Laura said, FLTMA, as she mentioned, describes several uses of federal lands. It also describes some values, and sure, I mean, conservation can be a value that the agencies keep in mind, but she's completely correct that the current administration is elevating non-use as a use above other uses that Congress, which to my mind more directly represents the people. Right? There are many legislators, federal legislators. They've said that, for example, it's important that we have quarterly oil and gas federal leasing. It's important that we have timber production, active forest management. It's important that we have grazing. Grazing is one of the highest and best uses under federal law of our federal lands. And so this. I just want to make sure we don't cabin the discussion just to the conservation leases or call it landscape health, whichever euphemism anyone on either side prefers to use, discussion, because there's a full-on executive branch wide attempt to take public lands away from the public. And so, I mean, there are several, but maybe countless, not quite accurate, but many matters we're involved in where we're taking this on. And that goes directly to, our work, not just for the ranchers and the active forest management, the recreationists, but also for the energy industries, right? Huge federal mineral estate. Congress has been clear for more than a decade that using that mineral estate is in the national interest. And yet we have a number of federal regulators who have decided otherwise. So we on many fronts, we fight that all the time. And the bulk of the cases that I take on and do involve this juxtaposition of the public interest is in developing these resources. So says Congress, so says the law. And at what point do we stop letting the unelected decide otherwise? There's a case that's in front of the Supreme Court right now. Our merits brief was due yesterday. And then we're involved in, though, where a single regulator decided that decarbonization is the national policy. That's it. That's that regulator's choice, not elected regulator, anything like that. And unfortunately, a group of appointed judges decided that that was correct also. Never mind what the law said, right? The law explained that public has other interests besides that. So that'll be an interesting one to follow if anyone wants to follow. It's called the 7-County Infrastructure Coalition case. But we're going to be involved in that. Briefing will go on through this fall. Hopefully there'll be argument probably in the spring, but in this term for sure. And so, we stay very involved in all these energy issues. Hopefully that
we may get
nailed it for you.
We may get a favorable decision out of the Supreme Court this term then on
That's
these
right.
topics.
That's right. We'll see how it goes.
So we do have questions. Thank you so much to our audience. Go ahead if you do have a question to drop it in that box. I'll let the panelists comment or not comment if they want to on the questions. The first one is about Agenda 21, which I think is related to something in the United Nations, but I'll expand it. I think we've also had other agendas like 30 by 30 that are out there. in terms of the future and doing more to encroach on liberty. What is it that we think is going to result in the liberty movement between the clash here? So we've got, on the one hand, people who are trying to grow the government, trying to encroach on liberty. On the other hand, groups like ours, lawyers like three of you, that are working on this issue. How does this shake out over the course of the next decade? Ivan, do you want to start?
I'll start with the self-serving version.
Yeah.
Because it goes back to what I said earlier. Not only do we bring the important cases to maybe change or set precedent at the Supreme Court, but it goes back to what I said about Sackett, about Chevron deference, Loper Bright case, right? When we get a good decision that restricts the reach of the federal government, for example, it has to mean something, right? And these cases we take on afterward, right, are how we show what it means. So that's the real answer to me. To take on the good cases, to extend that and show that it meant something real.
Yeah. Norm, any commentary on the clash here that's going on between people who are trying to grow the government and the work that you are doing?
Yeah, I think the U.S. Supreme Court is stepped into the breach. I mean, whether you're talking about America the Beautiful, 30 by 30, Agenda 21, or whatever it is, remember, Congress makes the laws. So if Congress isn't making a law in this area, the agencies are not free. And this is where the cases we've been talking about, Loper Bright, doing away with Chevron deference and the major questions doctrine, step in. And Ivan's exactly right. We pick and choose the right cases to go in to enforce what the Constitution says, that Congress makes laws, not the agencies.
Laura, any thoughts?
I would just, I look at history and how we got here. And I think, I would just point to the uptick in executive orders where presidents without the authority set certain policies, then the agencies respond as if that's the controlling law. And we saw that really, I think, under the Obama administration, out of a sense of frustration of not being able to get things done in Congress. And so, I mean, I'm sure there's other historical points where maybe that happened, but I know in my experiences in past jobs, that's where I spent a lot of time monitoring, because that's a signal from the president, whoever's in office, to the agencies. That's where a president gives direction to agencies. So if you're curious about, an administration's position, it's a good thing to look at that. One of the areas, which I'm not an expert on, but crypto mining. And the Biden administration has more than one executive order. And I think that we'll see that impact public lands, because there is a connection between crypto mining as well as siting transmission lines and electricity and energy use. So I just, it's interesting to see the administrations and how they approach the use of executive orders is the only thing I think I would add. I'm not familiar with Agenda 21.
No, but it's probably fair to say, you think you'd agree with this, that I think in the Obama administration, they began to use the laws at point of departure. Right?
Yes.
And so a lot of the work we do is bringing the regulators back to what the law actually is.
Yeah, absolutely. Well, thank you so much. We're going to leave it there. Thank you, number one, to our audience and, of course, our questioners. And thank you, number two, again, to our terrific panelists. What an interesting discussion we've had. Thanks so much to Laura Chartrand, Norm Semenko, and our own Ivan London for our So a Neighbor Asked what's going on with natural resources management. We will have a September webinar. Stay tuned. Watch your email and social media for announcements about the topic and date and time. But we are excited to do that. If you are interested in learning more about the cases that we discussed today, you can check us out at mslegal.org. You can become a supporter. You can submit good case ideas for us. And you can communicate with us if you have additional questions for Ivan or other panelists. And we are adjourned with that. So thank you very much to our audience and to our panelists. Thank you.
Good seeing you guys, Lord.
Thank you.